Okay, with the counsel for Platt and Osborne versus Fern. Oh, Arnold, I'm sorry. Too many names. Okay, are both sides ready to proceed?
Yes.
Okay, whenever you're ready.
May it please the court. My...
Yeah.
If you're parked illegally in our parking lot, we're going to tow you. You need to move your car. Thank you. May it please the court.
That doesn't apply to you, does it?
Hopefully not. No, in the parking garage across the street. So. My name is Bill Henry, and I, along with my law partners Les Burke and Joy Kimball, represent the appellants in this case, the successor co-personal representatives of the estate of Dick Arnold. I'd like to reserve 4 minutes for rebuttal.
Okay, I'll try to remind you the clock's in front of you.
This case is before the court regarding a order of surcharge or a final judgment of surcharge against my clients in an amount in excess of $550,000. The primary issue in this appeal deals with an August 1996 order entered by the trial court, which the court subsequently later said was a final order. And the issue being that that was not truly a final order. That's the main point because that is the sole basis why the co-personal representatives were surcharged in this case.
But I've been struggling reading the briefs with the significance of the 1996 order being final or non-final. The facts are undisputed that the appellants dispersed funds contrary to that order. They didn't attempt to have the order revised so that their dispersal would be consistent with it. It seems to me violating a court order carries with it a substantial risk. What difference does it make whether it was final or not? It was violated.
I don't disagree with the fact that a violation of a court order may subject an individual to a sanction. What is different in this case, and I'll also admit that the administration of the estate may not have been what would be a perfect administration of an estate. However, the 1996 order is significant of why it was final or not because the sole issue that it was dealing with was apportionment of taxes. And if you look at the apportionment statute, the Florida apportionment statute.
Was it apportionment of taxes or actually the payout under the will?
The 96 order just dealt with taxes apportionment. If you review it, what it talks about is that the taxes shall be apportioned to the specific bequests as opposed to the residue, and it has a specific fractional amount allocated to those specific bequests. That was the only issue that's addressed in that 1996 order. And it's significant of whether it's final or not because of the apportionment process. That order was sought in 1996 as a tool in helping the personal representative. And mind you, at that time, the personal representative was Helen Arnold, Dick Arnold's spouse. Our clients, the ones that have been surcharged, were the successor co-personal representatives that were appointed. But that order was entered as a tool to assist in preparing and filing the estate tax return. And why it's important is that in filing that tax return, not only what the amount of tax is important, but in this case, who is being taxed is important in determining the amount of tax. So that order was sought as a way or a construction or interpretation or an analysis of this estate to try to minimize the tax liability. After the tax return was filed, the IRS objected to the analysis that's contained in the 1996 order, suggested an alternative analysis. The amount of the taxes increased somewhat, but they also said that there are other issues we have here concerning valuation of assets of the estate. And a period of 3 years went back and forth between the professionals hired by Helen Arnold at the time and the IRS tax examiner until Helen Arnold died in 1999 and the co-personal representatives were appointed. And due to the loss of the benefit of the marital credit, which the residue in this case was the marital credit, the determination was made to settle with the IRS. Now, in the apportionment process, and the statute, throughout that statute, it talks about the amount of the taxes, the amount of the taxes, the amount of taxes. And that under the statute that's applicable to this estate prior to the 1997 amendment, an apportionment order was only talked about after the taxes were determined and paid. And that's the key point here. The 96 order was 3 years, well, it was entered before the taxes return was submitted, and 3 years before the taxes were finalized and paid. And since
Well, help me here, because
Yes.
I got a little confused too. The IRS took the position that they were only bound by a Supreme Court of Florida decision. But, and I understand that. But after the IRS determined the amount of taxes, or there's an agreement in the amount of taxes, that by itself did not amend Judge Sherman's order, did it?
No, Your Honor.
And the reason I'm saying that is because the IRS doesn't, once the IRS figured out how much they got, they didn't care who paid it, right?
Well, I disagree with that
Well,
point.
as far
because
as determining, I understand
determining,
that.
it depends on who's paying because of the way that this estate is set up.
Yeah, and I understand. I mean, the IRS in determining how much taxes are due has to determine their theory of the distribution.
Correct.
But it still doesn't act as an amendment to Judge Sherman's order, does it?
No, it doesn't, and I think you're referring to the Bosch case and the Rapp cases that the appellees have cited, and those are irrelevant for purposes of this, because in those, especially the Rapp case, there was a presumption that the order that the state court had entered was a final order. There is no disagreement in reading the Rapp case as to whether that order was final. And what the appellants were trying to say in that case is, hey, we're bound by the state court ruling. We can't go back and change it. The IRS ought to have to accept that because we would have an incongruous situation there. In our case, the issue primarily at this point in time is whether that order was final. So it distinguishes the Rapp case and the Bosch case.
But I go back to Judge Van Ortwig's question. Once you had determined an amount of taxes, if you felt the circumstances and situation had changed, wasn't it incumbent to go back to the circuit court and readdress the issue?
And, Your Honor, in hindsight, would a better practice have been to go back and get that clarification or an amendment prior to making the distribution to the trust? I most certainly agree with you that, yes, it would have been.
At that time, was there any bar to going back to the circuit court with a motion for reconsideration?
There was no statutory bar or otherwise, and in fact, the statute suggested that once the taxes are paid, you get that final apportionment order. Now, in this estate, it didn't become an issue until 3 years after the taxes were paid, 6 years after the order was entered, when the contesting beneficiaries, the appellees in this case, filed their petition for surcharge. We did, timely at that point in time, immediately thereafter, ask for a modification of the 1996 order. And the hearing was held in August of 2004, where that issue was noticed. The appellees had also asked the court to find that the 1996 order was a final order. As a result of that August 2004 hearing, the court sent the parties to mediation, and when the case didn't settle, the only order the court entered was one saying in March of 2005 that the 1996 order was final. Interestingly enough, we timely appealed that ruling at that time. This court, which gets notices of appeal all the time regarding orders and things of that nature, sent out an order to show cause why the appeal shouldn't be dismissed because it didn't appear that the March 2005 order was a final order. And that's the problem with some of the probate procedure, is that there are many different types of orders. There are some things that have a process that goes forward, such as like the Dempsey and Rogers cases that we cited, of dower and elective share, where there's a process. And until you get to one of two things, the end of judicial labor on certain matters, and when you have an order that shows the language of finality, only at that point in time do you have something that's appealable. That's another distinguishing factor about the 1996 order as to whether it's a final order or not. It doesn't have the traditional language of finality. It doesn't say it's final. It doesn't say, let execution issue or anything of that nature. So it doesn't have the common terms if you're looking at it. It also...
But let's assume it wasn't final. Let's assume the trial court here erred in concluding that the 1996 order was final. Didn't the respondents still breach their fiduciary duties by paying taxes and making distributions contrary to the 1996 order?
From the standpoint of if it's a strict construction, you violated an order, you need to be sanctioned. That's one thing, and that may be a contempt. However, a surcharge of $550,000 when you had two lay people that hired accountants and experts, as they're permitted to do under Section 733.612, and rely on their advice without independent investigation, is a pretty severe sanction. And your question gets to the second and fourth points, really, of our brief, and that reliance on advice of accountant and attorney is not an affirmative defense, but even if it is, that the court in this case abused its discretion in denying us leave to amend.
Well, didn't the Gauze case say it was affirmative defense? Is that my memory?
The Gauze case was cited by the appellees and was addressed by the court, but it's completely different circumstances.
But the legal question as to whether reliance on advice of counsel, that legal issue is the question of whether that's an affirmative defense that has to be pled. You say the law is clear that it is not an affirmative defense?
The Gauze case, in those circumstances, the Gauze case said it was an affirmative defense. We don't believe it's an affirmative defense because under the probate code, section 733.612, there are different grounds as to a personal representative in how they discharge their duties. And one of those things is that they can hire attorneys and accountants and rely upon their advice without independent investigation. And that when you're judging whether somebody breached their fiduciary duty, that's the applicable law. But even if you say, okay, the Gauze case is applicable, which we don't believe it is because, A, there's no notation in that case that the defendant ever asked for leave to amend, and I would say it's only applicable if the court would have granted our summary judgment on those grounds and that the appellees would have been the appellants in this case arguing that we should have pled it. But at the time that we requested leave to amend, which was at the hearing in September of 2005, we had 7 months until we had a final evidentiary hearing in this case. That was a non-evidentiary hearing in September of 2005. That was the first time it was ever raised as being an affirmative defense that was waived.
You're down 4 minutes.
So you're saying it's the trial court abused its discretion under those circumstances?
Yes, Your Honor. If I may answer this question, reserve the remaining time. As this court stated in the case, correctly stated the law regarding leave to amend, is that it should be freely given when the circumstances justify it, and that it is actually an abuse of discretion by the trial judge to deny leave to amend unless three things exist. That there would be no prejudice to the opposing party, that the party requesting leave had not abused the privilege, and that the amendment would not be futile. None of those things exist in this case. We had 7 months that the appellees could have conducted discovery, and in fact, they did ask some questions that were answered by the co-personal representatives in their depositions regarding conversations that they had with their attorney prior to making the transfer to the trust. Also, we had never asked for leave to amend or answer the petition for surcharge, so there was no abuse of that privilege. And finally, it would not have been futile to allow the amendment, as evidenced by the testimony that was proffered at the trial, as well as the personal representative's affidavits attached to our motion for summary judgment, clearly spells out that prior to making that decision, they had that discourse with their attorney and their accountant, and were not instructed to not transfer the money. In fact, had been given tacit authority to go ahead and transfer it even after the 1996 order was entered. Thank you.
May it please the court. My name is Greg Olson. I represent 25 of the 34 residuary beneficiaries of the estate of Dick Arnold. Those were the petitioners in the petition for surcharge below. First, I've got all my notes here. I'll throw them out the way and just respond to some of the things that appellant said. On this question of the reliance on advice of counsel, the first is the proffer showed that the defense doesn't exist. Reliance on advice of counsel, there must be actually a legal opinion analyzed by the lawyer, and he must then give that opinion to his clients as advice. And it would have to go to the question, can you go ahead and ignore Judge Sermons' order and fully fund what they refer to as the $1 million trust? In my brief, I call it the Arnold Trust, but that was the specific bequest of $1 million. Is it okay to go ahead and pay out that money? Judge Wolf is one of your first questions in this case, but the order was intact. It was in place. How can you just ignore it? And there would have had to have been advice given by Mr. Burke to his clients through some analysis, I'm not sure what it would be, that it was okay to do so. The evidence, or the testimony, I should say, at trial given by Mr. Burke was simply, I never told him not to do it. The testimony of the two respondents was the accountant and lawyer never told us not to do it. That is not advice of counsel. That's an absence of advice. So the proffer doesn't establish a defense in the first instance. Now, when we go to the question of the discretion of the trial judge It's what was oh, one last thing. This idea of throwing in the issue of affidavits now that wasn't mentioned at the trial court, wasn't mentioned in their briefs. That wasn't before the trial court as evidence in this case. That would have been hearsay. It was in a document I filed at the time. I said it's improper to consider these affidavits. It was something on a motion for summary judgment. It's the testimony at trial that counts. And that testimony defeats the defense of reliance on advice of counsel, even if it had been let in, or even if they had timely requested leave to amend, or even if the judge, under these circumstances, had abused his discretion. So let's look at what the circumstances are. Of course, as trial approaches, leave to amend, the ability to get leave to amend starts declining rapidly.
But the appellant has argued that there were 7 months, there was plenty of time to do additional discovery, so there would not have been any prejudice here in granting leave to amend.
Yes, sir. Let's go back to emphasize the point I was just making. It's what was before the trial judge at the time. The hearing was on September 20th, 2005, where it was petitioner's motion for entry of final judgment, and they filed a response and we filed a reply. And at that time, because they had for the first time brought up this issue of reliance on counsel, even though the trial had started back in 2004 and was continued at the request of the respondents to get one more chance at mediation. At that time, the judge then, a month or so later, entered his written order denying the Oratennis request for leave to amend, said call for a hearing date. There is nothing to show that the judge didn't know that the hearing was going to be set immediately. And as a matter of fact, sometimes it takes time clearing calendars before you actually get to a hearing date. So the fact that it ended up taking that amount of time, you should not look at this in retrospect. You should look at it, Your Honor, and what was before the trial judge at the time. And he's looking at this. This factual information was known to you since 1999 when you paid this out. We're now 2005. You filed your answer in this case 3.5 years ago and never raised it. We started the trial in this case in August of 2004. You never mentioned it once. And now when all of a sudden things are closing in, as sometimes parties do, they're trying to come up with new ideas or new theories to save their position. So the trial judge had no way of knowing that it was going to be 7 months. And another thing of significance is that the respondents never asked to renew their motion if they should have. But really, under all these circumstances, where the trial has actually already commenced and 6 years has gone by to raise this, then I think that when you take all of these matters together, that the trial court clearly was within and the trial had already started. He was clearly within the proper exercise of his discretion. But then all of that, in my view, respectfully, is out the window anyway, because when you look at the proffer, they could not establish the defense in the first instance. Going back to the question of finality of the order, I certainly am of the opinion, or I wouldn't have argued it so strenuously, that it is a final order under Probate Rule 5.100 in effect at the time. It's if a particular matter is resolved and tells the rights of the parties, then that is a final order in probate. You have a series of building blocks in probate. You first have to have a final order admitting the will to probate.
Well, I asked this question of appellant's counsel. I'll ask it of you.
Yes, sir.
What difference does it make whether it was a final order? Wouldn't we be in the same place if there had been a violation of a non-final order?
As I've argued in the answer brief, I agree exactly with that point. And we state there are two reasons that even if it were not a final order, that the final judgment on the petition for surcharge must nevertheless be affirmed. The first is not the one that you were getting at, and I'll get to that secondly, if I may. The first is that the order correctly interpreted the will. With respect to Mr. Burke and with respect to the IRS agent, they were both dancing back and forth as to why the will said what each side wanted to say. The IRS wanted to say, it says pay from the residuary estate, so you have to pay it from the residuary estate. What the IRS agent didn't say was it also says the marital deduction trust must be undiminished by death taxes, and after the codicil in this case, that was the residuary estate. One part of the will says you have to pay it from the residuary estate. That's the first statement. The second statement in the will says you cannot diminish the residuary estate by death taxes. Those are in irreconcilable conflict, and that's why we have a rule of will construction to be able to move past that point. The second statement must control as the last expression of the testator's intent. So it was always correct, and therefore Judge Miller couldn't have properly changed it because it was correct in the first instance. Now the second point, which I think is what you were getting at, and I apologize for taking a minute to get there, but the second point is that order of Judge Sermon's is still an intact order of this probate case. It said, here's what the will says. It interpreted the will, and by the way, orders interpreting the will by case law are, by definition, final orders, but it interpreted the will, and it said, this will says all the taxes must be paid from the specific bequest, including the trust that the respondents happened to be co-trustees of, and one of them was getting $5,000 a month out of, so there was a personal interest there, that's where the taxes must be paid from, and none must be paid from the residuary estate. We proved our case, not by any great genius on my part, frankly. I mean, it was almost all admitted in the pleadings. All the facts were admitted. They were just trying to find theories after the fact, like when the effect of the apportionment statute and so forth. So it was proven. The order existed. They violated it. The damages add up very simply. They paid out $352,000 from the estate to the Arnold Trust that they shouldn't have paid. It was a simple mathematical calculation of damages, $352,000 plus prejudgment interest. They didn't prove any defense. The one defense that they kind of tossed in sideways in both their briefs was that there had been a statement in an accounting that vaguely referenced this without explaining. There was an order that said to the contrary. We raised a big reply to that defense, but we never got there because at the trial, both segments, August 2004 and April 2006, never once was that issue mentioned by anybody in the courtroom. So it was never even mentioned, much less proved, so we never got to the reply evidence. That was abandoned. The only other thing was modification as an affirmative defense. They relied on the wrong statute. They relied on the apportionment statute that came into effect after the one that was applicable to this estate based on the date of death. And they never went anywhere with that. And the matters that were also set for hearing in August, the petition for apportionment and a separate petition for modification, they were abandoned as well. The hearing was continued at the request of the respondents for another shot at mediation. We got our petition rescheduled for trial. They essentially abandoned theirs, and it was never reset. So I agree exactly. This court cannot countenance an estate through its personal representative going to a trial judge, asking for an interpretation of the will as to where the taxes are to be paid from, and that's what it all said. The notice of hearing, the order, it wasn't part of a petition for apportionment. There was never a petition for apportionment filed except in a defensive posture some 6 years after the entry of the order by Judge Sermon's. 6 years later, only after they got caught, got sued. And when I say got caught, when we came into the case, my brother Mark and I came into the case representing some of the parties, it was years after the entry of the Sermon's order. We were preparing, as the evidence shows, and as the record establishes, we were preparing for a hearing on another matter in this case in January 2002. We discovered the order in the file. We discovered that the personal representatives had just ignored it and gone exactly to the opposite of what it required them to do. We raised this issue. We told them this claim will be presented, because at that time it was how much money was in the case to make a partial distribution to show an extra asset. We said that you're subject to surcharge. At that time, there was still $270,000, as the record shows, in the Arnold Trust, that $1 million trust. And instead of freezing it in place, since that was approaching the $352,000 that had been improperly overpaid to the Arnold Trust, they kept paying it out, including $5,000 a month to one of the beneficiaries of that trust, who was also a co-trustee of that trust and a co-personal representative, one of the respondents, Mary Lee Osborne. It was in her own interest to get $5,000 a month. And notwithstanding the knowledge of this claim including after our petition got filed later that year. They kept paying out all the money, so by the time we came to the final segment of trial before Judge Miller in April of 2006, everything had been paid out. I'd like to go to just quickly on the matter of damages. There's one area that I would like to clear up. But the first point I would like to say that, of course, the record clearly supports the calculation of damages that Judge Miller made and awarded. It was how much money was paid out of Dick Arnold's estate, contrary to the sermon's order, and contrary to the will, because all the order did was correctly interpret the will. It should not have come out of the residuary estate. It should have been charged proportionally against the Arnold Trust. So the damages were simply what was the excessive payment. In Re Estate of Winston says improper or excessive payments subject the personal representatives to surcharge. They overpaid by $352,000. It's clear. Take $352,000, apply the statutory interest from the date the excessive payment was made, and that was the amount of the judgment. The respondents have basically, and I say this respectfully, but it's the term that comes to mind, it's the smoke that starts coming out on this issue. And that one of them is, really look at what a good job we as personal representatives did in some other respect, negotiating with the IRS on valuations and so forth. For starters, that was their duty. That was their duty not to overpay taxes, and it had absolutely nothing to do with diminishing the amount of damages they caused the estate by violating the will and the sermon's order and paying all the taxes out of the residuary estate, contrary to what the will and the sermon's order says. And another point on that, Les Burke testified.
What was the evidence in the record about this $610,000 so-called estate savings, tax savings?
I'll address that. Mr. Burke testified that at the same time that the respondents acquiesced to the IRS's interpretation of the will, which, with all due respect, I feel strongly was wrong. I think you apply the rule of construction as to the last statement and you get the same thing as the sermon's order. But Mr. Burke said at the time we acquiesced, we also then, in effect, got our way with the valuations of the Magnolia Beach homestead and some other properties. Now, assuming Mr. Burke's testimony to be accurate in that respect, his conclusion as a matter of law as to a potential savings of $610,000, I'm saying first, even if that were true, it still doesn't require the court not to enter the damages amount for paying it out of the wrong part of the estate. But even if he was able to get these valuations affected to potential savings of $610,000, I mean, it's only maybe yes, maybe no, but where his legal conclusions were wrong, if that analysis as the valuation was done in Dick Arnold's estate, legally it wouldn't have affected the amount of taxes, because the only thing taxed in Dick Arnold's estate, the husband who died first, were the specific bequests, mostly the $1 Million Trust and a couple of other minor ones. You deduct from that the unified credit amount, which was then $600,000, and impose the tax. That's what was done. Any valuation efforts done in Dick Arnold's estate would all have to be redone when Helen Arnold died, with marital deduction. So it would have made absolutely no sense. And the other thing that they...
Thank you.
Oh, sorry. Thank you very much.
Please, Court. First, I want to again address the issue on the finality of the order and why it's important. This Court also has to view finality of the 1996 order from the perspective of the personal representatives. And when you're doing that and you're looking at the Florida apportionment statute, even the old one that was applicable to this estate, that statute talks about examining the will. There are some presumptions there. You file the tax return, and after the taxes are paid, you come back and get a final apportionment order. There's further procedure relative to the personal representatives, where either they have to take the amount of taxes, apply the apportionment order in terms of withholding money and making it a distribution, or if money had already been distributed, then they need to go after the party to try to collect that money. And there's also a provision in there where they can apply, a personal representative can apply to the court to get relief from that collection matter. And what we're saying is we are here today on the surcharge matter because the court in 2005 said the 96 order is final. I'm not going to hear your modification. We didn't abandon our request to modify the 96 order because in March 05, when the court entered the order saying it was a final order, the court wasn't going anywhere with modifying that order at that point in time, and we tried to timely appeal that issue, which this court, and that appeal was subsequently
Counsel, is
dismissed.
there any proof on the record of, on the affirmative defense of listening to the accountant or the attorney that there was an affirmative opinion that you do not have to follow the sermon's order?
In terms of the proffer at the trial, no. And I'm not saying that there was an affirmative, go ahead and make the distribution by the attorney or the accountant. However, what the proffer did show, and if you read the transcript of the final hearing, it is kind of choppy because a proffer is being made in the midst of testimony with objections being raised by Mr. Olson at the time as to whether we're still within the proffer or not. But the proffer indicates that the PRs knew about the 96 order. Obviously, the attorney knew about the 96 order. The PRs wanted to transfer the money to the trust. The attorney was aware that they were intending to transfer the money to the trust and that the attorney never advised them not to transfer the money despite the knowledge of the prior order and the fact that they intended to do so. If you go back and look at the affidavits that were filed in conjunction with our motion for summary judgment, which incidentally was what the court was addressed with when we asked and made the oral motion for leave to amend, and really that's when you should judge as to whether the amendment would be futile or not. Those affidavits clearly indicate I had a conversation with my attorney, and we were advised to go ahead and make the transfer at the time.
Okay, your time is run. If you just sum up real quickly.
In terms of a summary here.
But counsel, let's backtrack for a second. Is it your position that this evidence you were trying to proffer as affirmative advice on the affirmative defense advice of counsel comes within parameters of the official affirmative defense of advice of counsel?
To the extent that the court would view it as an affirmative defense, yes. To the extent that we fit within the parameters of 733.612 that allows them to rely upon their professionals that they hire, then definitely the evidence comes within that in terms of whether they properly discharge their fiduciary duties or not. And that's truly the issue here, is whether these lay people who hire these professionals.
Okay, counsel, but what I think I'm hearing you say is anytime a personal representative hires an attorney and accountant, that unless the attorney or accountant specifically says, no, you can't do that, they are covered or protected under the statute.
I mean, I think a lack of advice can also be advice. A lack of saying don't do something when everybody knows what's being done.
Isn't the logical extension of your opinion that when you have an attorney and an accountant, that unless you have an affirmative advice going the other way, that you have the protection under the statute? I mean, isn't that where you're headed?
I don't think you need the affirmative advice, but if there is a lack of saying don't do something, then it still fits within the provisions of the statute.
Okay, your time's run. Thank you.
Thank you, Your Honor.